Welcome to Family Law Talk. Family Law Talk. Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a multi-state family law firm. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is the importance of deposition objections. And this episode today is based on an article on our blog, familylawheadquarters.com, dated June 4th, 2024. And the title of that article is How Deposition Objections Work. So as a follow-up to the episode today, go on over to familylawheadquarters.com and read that article. It'll give individuals interested in this topic more information. But let's go ahead and jump on in. Depositions are common in divorce or family law matters. The truth of the matter is all sorts of witnesses may be deposed. The parties themselves, typically in a case that's going to be tried, takes place. So a deposition of the petitioner, deposition of the respondent, very common. And then there could be depositions of third-party witnesses who have information relevant to the proceedings. And then another option would be expert witnesses. So if either party has hired expert witnesses to offer opinion-based testimony in the case, typically their deposition would be taken as well. And the list of potential experts in a divorce or family law matter is long, but it could be a business evaluator or maybe an accountant. It could be a vocational expert, a custody evaluator, maybe a real estate appraiser, a medical doctor, and really a number of other potential experts could be called as well. Again, once they're disclosed, typically the other attorney wants to depose these individuals to find out what they have to say. And so, past that, many ask, well, how does a deposition work? Well, look, a deposition works like this. The party who's being deposed is sworn in under oath, and they're asked questions under oath by the attorneys. And that's typically how it works. Now, normally it's not in a courthouse or in a courtroom. Typically it takes place in one of the attorney's offices, but in theory it could be somewhere else as well. Some third-party location. Maybe it's at the doctor's office, let's say, if a doctor's being deposed or something like that. But typically outside a court, and they're under oath. In terms of how depositions, how long they can take hours. In theory, they could take a day, or maybe they even take days. It just depends on the case in terms of what they have to say and perhaps how much time the judge allows. Oftentimes, it's pretty wide open in terms of how long an individual could be deposed. It's really based on the substance of the case and what the witness has to say. Okay, so typically the way this works is if the deposition of petitioners taken place, the respondent's attorney is going to ask the petitioner questions under oath. Then if there's a guardian ad litem, they can ask questions of the witness under oath. And then typically the petitioner's attorney could ask them questions under oath if they like. Oftentimes they don't, because if they have questions for their client, they can do it outside the presence of the other attorneys. But there could be some reason, maybe a lawyer wants to put something on the record, and so maybe they do ask questions of their client, but not very common. And normally if that takes place, it's not a lot of questions. Now, in terms of objections, look, in a typical deposition, there's going to be some number of objections put on the record as part of the deposition, okay? And this can happen really a couple of different ways, okay? So let's say petitioner's being deposed. Let's say respondent's attorney's asking the petitioner questions. Let's say petitioner's own attorney wants to object. They might say, objection, I object to this question. I think it calls for speculation, but subject to that objection, you can answer the question. So typically what happens is a lawyer objects. They state their objection on the record. Their objection could be really a number of them. It could be based on relevancy. It could be based on hearsay, speculation, the form of the question, like maybe it's a compound question, or numerous other legal or evidence-based reasons. They could put an objection on the record and then say, subject to the objection, you can answer the question. And when individuals hear this, they say, well, what's the point? If they're objecting, but then they still have to answer the question, what's the point? Well, look, the attorney's preserving that objection for trial. All right? By objecting, they're preserving it, and they can bring the matter up to the judge if this deposition, let's say, is going to be introduced as evidence, or if the same topic is going to be inquired about at trial. The lawyer can say, no, I objected at the deposition, and I'm objecting again to this being inquired about in court, okay? So objecting merely preserves that objection for court-based reasons if the case is tried ultimately, okay? Or somebody's seeking to admit the deposition into court. Now, the other variety of objections is when an attorney objects and then instructs their client not to answer the question. Okay, so take attorney-client privilege. Let's say, the other attorney asks the petitioner what petitioner and their attorney talked about. Well, the attorney might say, objection, this invades on attorney-client privilege, and I'm instructing my client not to answer this question. Let's say a question is asked, and it calls for what's called the work product privilege. Which, again, I don't want to get too in the weeds on, but this is trial prep strategy kind of issues. So in theory, an attorney could object and instruct their client not to answer that question. Let's say a question is so far out the bounds of what's been pled, what's relevant in the case. In such a scenario, in theory, an attorney could object and instruct their client not to answer the question. Again, to use a baseball analogy, if the ball is way off the plate, so far off the plate that the question's unreasonable, that's when an attorney might instruct their client not to answer the question. But if the pitch is kind of roughly on the corner, maybe a little bit off, typically an attorney would object, and then subject to the client's able to answer the question itself, okay? So it's important to distinguish an objection, but then subject to the witness answers versus objection, I'm instructing the witness not to answer the question. So let's take the latter. Let's say it's a situation where the lawyer objects and they instruct their client not to answer the question. Then the issue is, well, what happens then? Well, there's really a couple options. Option one is if the attorney who's asking the question thinks that it's really a relevant question, what they do is certify it on the record. So they then ask the question again. The attorney states on the record, I'm instructing the client not to answer the question, and the attorney would typically say, on the record, I'm certifying this question. And then what happens is the matter is brought up to the judge, or if there's a special master who rules on objections in the case, then they rule on the objection. And if the objection is overruled, then you got to go back and complete the depo another day, and the individual needs to answer the question. If the objection is sustained, then that's that. Another option might be a lawyer might say, well, this question really isn't that important, so I'll just move past it, not really seek to certify it and bring the matter before the judge or the special master. But that's really the choice a lawyer has, which is certify it and then try to get the judge or special master to force a response, or just waive the question and not seek an answer. Okay, so those would really be your two options. But for anybody going through a divorce or family law matter, or anybody who's going to be deposed, I mean, really the issue is this, is for you, if you're going through a divorce or family law matter, obviously follow the advice of your attorney, talk about these kinds of matters with your attorney in advance. Obviously the laws and procedures could vary slightly in a different state. I'm just explaining how things have generally worked with depositions that I've been a part of throughout my career in terms of how I've seen it. There could be nuances and quirks in your jurisdiction, so definitely consult a lawyer who's licensed and competent to practice law in your jurisdiction. But for any party who's being deposed, if you've hired an attorney to represent yourself or to represent you at the deposition, then you typically want to follow the lead of your attorney. So, if your attorney tells you to not talk, not answer the question, then you typically wouldn't do that. You'd follow your attorney's advice. At the same time, if your attorney objects and says subject to you can answer, then typically you would answer the question. But, going through this in advance, going through different topic areas that might come and having a thorough discussion with the attorney in advance can be an important thing. Sometimes there can be a recess or a break in a deposition where maybe a client and lawyer can discuss and talk about it in more detail as well. But I just think for a lot of individuals, this whole concept of deposition objections is sort of foreign to them. They haven't seen it, and they don't really know how it works. And that's why I wanted to cover this topic today. It's kind of an in-the-weeds topic a little bit, but for anybody who's been deposed before, they're going to see this, and it's important to know, generally speaking, how it works. So hopefully we've covered this topic in a way that will help individuals who are listening to this episode today better understand it. Okay, so that's the topic again today. It's about deposition objections. Again, as a follow-up to the episode, go on over to familylawheadquarters.com, read the article titled How Deposition Objections Work. It'll give the listeners more information on this topic. But thanks for tuning in today. We appreciate you listening, and stay tuned to our next episode of Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision and should not be based solely on advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtained in this podcast is not, nor is it intended to be, legal advice. You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. Past results afford no guarantee of future results, and every case is different and must be judged on its own merits. Kirk Stange is responsible for the content. Headquarters, Office 120 South Central Avenue, Suite 450, Clayton, Missouri 63105. Kirk Stange is licensed in Missouri, Illinois, and Kansas.